sometimes I will load these blocks into my computer, and I will look at just how pale I am and realize how much I truly need a vacation at some point soon, as I'm turning Casper color, and that's just not normal for a human being. So in this blog, I just want to quickly cover a few things about the meeting of the creditors, which is another bankruptcy sort of issue that gets overlooked a lot of times. So you filed your case, right, and you're about to go to the meeting of the creditors. What can you expect? A lot of my clients look at that before they actually even file a case or find an attorney to file a case for them. Why? Because the whole thing sounds really ominous, a meeting of the creditors, as if Amex, Visa, MasterCard, Discover, the good people at Bergdorf Goodman, and everywhere else sit around the table and wait for you to show up, when in fact, that just never happens. While the meeting of the creditors is taking place so that creditors can show up if they want to, they rarely, if ever, do. Typically, you'll see a random landscaper that'll show up and say, "Why didn't you pay me?" Or some sort of a food vendor once in a blue. But in over 95% of my cases, no one ever shows. The reason is because they've basically written off your debt some time ago and they have no questions to really ask you. So you don't have to be concerned about the creditors actually showing on that particular date. Here's what happens, though. So you walk in, and your attorney is hopefully there early with you, because we prep you ahead of time, and you should be prepped ahead of time for the questions that are going to be asked of you. It's about 5 minutes worth of questions, and I'm going to break this sort of series of video blogs into about 3 or 4 parts and take each one as it is, just so you understand fully exactly the questions that are likely going to be asked of you. You walk in, and typically what I have you do is sit there for about 30 minutes prior to the actual meeting time. So let's say we're scheduled for 10:30. I have you get there at 10, so you can sit there, get a feeling of the trustee. Each of them have their own personalities that you have to get accustomed to. Some are very, very grumpy people. Some are incredibly happy people and normal people. So you want to get accustomed to that. You also want to see the questions that they ask. And moreover, when you get to see other people do something, you're less nervous when you actually have to go up and do the same thing yourself. So you're sitting there and you're waiting, and your name gets called. And I let out a scream, and so do you. And then we walk up to the table, and you show a picture ID and your social security card. Trustee checks that. Trustee asks you to raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth. You do. They'll ask you if you've reviewed the petition before you signed it, and you have to review that petition before you sign it. It's literally the law, but more so now, you see some people that come in and say, my attorney just filed this, and that's a big no-no. You have to review that entire petition before that's actually sent in. So yes, you reviewed it before you signed it, hopefully. They'll ask you if that's your signature. They'll point to your signature on something called a voluntary petition. Yes. And then they'll say, did you read through everything? They'll ask you again. Yes. Do you want to make any changes to the petition? Around this time, if the attorney wants to make any changes, the attorney can say, yes, I want to amend this, or I want to amend that, or the car that was there is no longer there, or, my client was working, she's no longer employed, or he's no longer employed. But if you don't, you just say no. The trustee will ask if you've listed all your assets and all your liabilities. Hopefully you have. After that point, the trustee will go into a discussion of typically, what do you do? So if you're employed, they'll literally ask, what do you do? Say what you do. Some trustees will ask you exactly how much you earn in a month, sometimes net, sometimes gross. So again, this is something we go over before the meeting. You want to be familiar with that. Why? I think on a subconscious level, to be honest with you, the trustees will see that you're prepared. I don't know that this actually, is something that they think about, but we prepare our clients in this way. Trustees want to know you're prepared for it. So if you know the answer off the top of your head, it's much better than sitting there and going, some months I earn one, because then the trustee gets pissed and they start to get grumpy. There's 30 people in the room. Not a good way to start off. So again, you want to prepare your net income or your gross income and know those facts before we actually walk into the actual meeting. They'll ask you about that. They'll ask you sometimes whether or not the income and expenses that are listed are completely accurate. So there's a separate schedule in your papers that will list the actual expenses that are there, and they'll make sure that that's accurate. Yes, and it typically shows that there's literally no money left over to pay any creditors. Otherwise, you can go to Chapter 13. But they'll ask you questions about that. They'll ask whether or not you own a home. If the answer is no, that's great. There's a second step to this, which I want to talk about in a little bit of detail, just really quickly. You don't own a home now, but Typically the follow-up questions, which sometimes people aren't prepared for, are, have you ever owned a home? Or have you owned a home in the last 6 years? A home, co-op, condominium, whatever. If you're not prepared for that, and that question arises, and you actually own something, let's say 3 years ago, and you sold it, even if it was for a loss, it's not a great thing for it to come out at that point, because you want to make sure to supply all those papers to the trustee ahead of time, even if it's not requested. We like to send more than what is typically necessary because we want the trustee to know that we're just being completely honest. Here's exactly what the debtor's financial life is. Here's exactly what transpired prior to this. And so, again, you want to be prepared for that. Not just do you own the home, but have you owned the home, co-op, or condominium in the last 6 years? Or has your name ever appeared on the deed of any piece of real estate ever anywhere in the world? Another question that's typically not prepared for in many situations that you find in court. You want to know that that question is going to be asked. So they'll go around, those questions. If you did own a home, we provide documentation surrounding that home, be it the HUD-1, which is basically your settlement statement, the contract itself, anything showing the description of exactly what transpired, how much it was sold for, if it was a short sale. There's tons of variations now. And trustees are aware that realistically, no one really sold a house and made $100,000 and was sitting on the $100,000. That's simply not the case. What they're looking for is your past, your financial life. And so they want to see exactly what happened and when and why. So when you give them that info before, that meeting of the creditors goes by much more smoothly.